to the lecture on patent validity search. In this lecture, we will take up the aspect of when an invalidation search is taken up, particularly from the point of view of a defendant in a suit for patent infringement. So, how do you perform an invalidity search? The first step is to look at the claims in dispute. In this case, there could be one claim or many claims that one is looking at invalidating, and those need to be selected out, and then identifying the subject matter in relation to those claims. The step 2 is about identifying the prior art in relation to the claims that you want to challenge. The difference between the validity search to invalidity search in case where a defendant takes up is not limited to just the prior art. Well, the patent owner is typically looking at prior art from the point of view of the novelty and inventive step in those considerations. But in the case of where the invalidity search is taken up by a defendant, this has other facets to keep in mind. So, prior art is certainly a consideration, but beside the prior art, the defendant will be looking at potentially the prosecution history. Was it a scenario where a dependent claim in prosecution became later on an independent claim and was granted? Was it the case that the patent examiner did not allow certain claim terms to be taken in that particular way, in which case prosecution history provides important information on already the case of where a patent would have otherwise already got limited. So, a defendant is potentially looking at the prosecution history information or the file history information in relation to the claims which are under challenge. Besides, other grounds of revocation are already available under each law. So, those can be combined very effectively. So, often it is not just one ground that is taken up for invalidating a patent. One would obviously take up either novelty and non-obviousness together. One can take up novelty, the issue of lack of novelty, lack of the non-obviousness, and also lack of sufficiency of disclosure. So, when you strike a patent, you strike it on the novelty, but then you additionally tag in the aspects of lack of inventive step, lack of sufficient description. So, just to strengthen the challenge in relation to a particular patent application, the patent grant. So, therefore, here in this kind of a search, there is a consideration for factors even beyond the prior art, which are to be considered. So, therefore, it is also important to make sure to know the purpose of the invalidity search. So, in a threatened litigation scenario is one we are looking at. A failed licensing scenario may potentially put the parties into a case of a lawsuit. So, you are in anticipation of preparation for that is where you may be looking at an invalidity search. The context of invalidity search will be subtly different for certain areas of inventions. For instance, in the pharmaceutical area and in the biotechnology area, one needs to take into consideration the patent term extension. So, the total period of grant is counted with the patent extension period. So, that is where the consideration is. And of course, in many countries you have linkage. So, patent linkage is one important consideration where you are looking at it from the considerations of the not only the patent law, you are also taking into consideration the aspect of the drug law. Since litigation is a strategy, one needs to take into consideration some of these aspects when you are looking at patents. Today, the area of computer related inventions are also coming under a big challenge, and a lot of court battles are being taken up in relation to patents. The implementation of those inventions are in different contexts. So, looking at evidentiary considerations there are important. Many a time patents use mathematical expressions, and if you are looking at a prior art for looking at that mathematical expression, the patent itself may not give the equation, but one needs to make out in some sense that these are the ingredients or the application of that particular equation. So, there are challenges actually when one takes up an invalidity search. There are challenges in every area if you look at it from that standpoint. We discussed about the evidence of use is one consideration. So, many a time this becomes a big bottleneck also in terms of looking at the invalidity search. The third area, which is again important in relation to why invalidity searches are performed, is the area of patent transactions. As we all are aware that one of the important aspect of a patent right is its ability to be used as a property. Patent is a bundle of rights, and so therefore it has the notion of property rights. One can actually license out inventions, one can sell a patent. So, when you are looking at a whole series of a portfolio of patents, this scenario becomes even more predominant. Patents can be transacted in various ways. Buying and selling of patents is actually quite normal. Today we talk about companies selling out their entire patent portfolio. We are looking at patents as an important part of the assets of a particular company. So, when companies are merging, companies are acquiring, this is an important asset which is also a consideration, and patents often are worth a few $1,000,000. Given that in the transactions, patents form an important part. So, there are several reasons why an invalidity search is very relevant for a patent transaction, and this forms what we call the integral part of an IP due diligence process. So, in a buyer-seller meet in relation to patents, the first thing that comes into picture is what is the strength of a particular patent? Is it prone to attack on the context of lack of novelty, lack of inventive step and all of that, in which case a licensee will potentially be affected. So, another important aspect is that when patents are being transacted, the value of patents is realized from the point of view of the licensing fee. So, if the patent is essentially invalid, you are paying for a patent which is a bad patent. Therefore, conducting an invalidity search is important before you get into the negotiation table. So, therefore, assessing the strength of a patent becomes the first consideration, which means then it could be an assessment of a single patent or an assessment of an entire portfolio of patents in a buy or sell scenario. Many a time it is also about acquiring patents, change of ownership in relation to patents. You do not want to be in a scenario where you are ending up owning a bad patent, a patent which is inherently not valid. So, before you actually go to a negotiation table or you are looking at acquiring, it is important to conduct the invalidity search to assess patent quality from the standpoint of prior art and other considerations which are possible. That helps you to prepare well for transacting in relation to patents. Many a time in this entire negotiation, it is possible that the patent price comes down. The outcomes of court litigation largely reflect scenarios where in the world we have seen that the value of patents have come down wherever the patents have been invalidated, and often has led to a loss of value to a company. So, while patents are so safeguarded very well, it is also important to take into consideration that a patent can be attacked on many instances. So, doing a good invalidity search is essential to go prepared to the table for negotiation. Similarly, from the point of view of a buyer has a better negotiating advantage if the buyer has assessed the value of the patent or the patent portfolio. So, therefore, These things are again take into consideration again not only the prior art part, but all the other aspects of the relevance of that patent. In fact, in many cases patent invalidity searches are closely followed by what we call inequitable conduct searches. So, if there are any inequitable conduct issues that are there with respect to a particular patent, those get immediately flagged. Now, what do we mean by inequitable conduct issues? It is during the prosecution of a particular patent application, it is possible that the owner has not, the patentee, the applicant has not been compliant with certain aspects of the submissions. So, this can potentially raise inequitable conduct. If the applicant has had the knowledge of the prior art but not submitted, because in many jurisdictions prior art submission is a mandatory requirement, in some other jurisdictions it is not. So, wherever there is a clear cut prior art submission which is mandatory, and non-compliance of that can raise the issue of inequitable conduct. Similarly, the foreign documents filing requirement is mandatory. If those are not filed, it is possible that certain claims have not been awarded by other patent offices. That information is potential to the prosecution of a patent at a given patent office, and deliberate non-submission of that will again raise an inequitable conduct. So, when an invalidity search is being taken into consideration, that information becomes a potential place for the buyer to negotiate, that there is something doubtful about your patent, is what the buyer would raise to the seller. So, patent prosecution history is a very important consideration in this case as well. Today, patent documents become a potential place for starting of investment, and one patent can lead to setting up of a large enterprise. So, when someone is investing so many $1 million worth of money on a bad patent, what entails in the entire process is something which is not worthwhile. So, for patent monetization also, the invalidity search becomes an important consideration. Now, during the licensing mechanism, to understand the value of a particular patent application, it is also important to assess the validity. And so, therefore, looking at the option of the invalidity search becomes appropriate to fix the value of the royalty or the type of licensing mechanism. So, your negotiating ability becomes better if you could bring in this aspect that, well, there are other patents which are more useful than this particular patent. So, why is it that I need to pay more for this patent? So, one can actually go into that kind of ability to negotiate if you have done the invalidity search well. So, when we come to the common search materials that are available for a patent validity or an invalidity search, they could vary subtly, but essentially one is looking at the claims of patents, we are looking at the non-patent literature. Drawings, patent images become also very important from the point of view of looking at the considerations of disclosure. And then, since this search is done post grant, the ingredients of what we do for patentability search are somewhat similar, and any documentary evidence available which can potentially invalidate a patent can be used for the patent validity or invalidity searches. So, a lot of work goes behind into the patent validity or invalidity searches. This requires a lot of techno-legal expertise from the point of view of looking at claims, claim term interpretation, looking at claim scope, mapping of a product to a patent, which is called product mapping. So, these become very important because in a threatened litigation scenario, a full-fledged analysis of it, complete due diligence of this is necessary to now look at what are the next steps in litigation. Should you go ahead with the litigation or should you settle out of court? What are the other things which are important to move the case further on and build the evidence better? So, this area is another area which is requires a lot of building of skill in relation to patent search, and most companies actually outsource this to specific law firms or agencies which are actually good in different types of invalidity search. Again, depending on the area, whether it belongs to whether the patent belongs to the predictable arts or the unpredictable arts, there could be variations involved in relation to the invalidity search. We discussed about the patent term extension, which is relevant for. So, because of the relevance of other laws in relation to that particular patent in relation to a pharmaceutical or anything like that, one needs to actually strategize the context of the invalidity search. Sometimes you need to review the entire invalidity search. So, it is again an iterative process. Sometimes you need to put that on hold and then look at other favorable circumstances. So, maybe because you are waiting for an outcome of an existing litigation and then you would like to plan. So, understanding the strategy behind the search becomes very important in the case of invalidation search, because it is again a very broader perspective that one is looking at. Let us understand what is the difference between an validity search to a patentability search, because we just completed that in the earlier lecture. There are there are certain differences between the validity search and the standard prior art search. Now, in a standard prior art search, you are looking at the invention as a whole, where you are assessing the invention for patentability in terms of novelty, non-obviousness and utility. But here in the case of invalidity search, you are taking into consideration only certain claims of the invention. So, that is where the entire invention is not involved. And not only that, you are also looking at the interpretation of certain claim terms and the scope of that in relation to the prior art. So, it is a much more specific type of a search which you would do in relation to the invalidity or the validity search. Another important aspect of which is where the difference comes in is the relevance of prosecution history. Any previous litigation on related patents can again be potentially utilized. So, many a time what happens is patents can be in different types. There could be patents of addition, then there are patents of there is a divisional patents are available. So, they are part of one ensemble. So, if you are looking at a patent of addition, revoking the main patent would mean the substantially which may affect the patent of addition. So, there are these considerations one need to also keep in mind, which is beyond the purview of just the aspect of lack of novelty or lack of inventive step. The issue of priority itself can be a big question in the case of validity search. So, therefore, this does not arise typically, because the question of the date of invention is a consideration just for the case in the case of patentability. But since it is validity search is done post grant, where a priority issue comes into picture, that becomes an important consideration and a difference which one can realize in relation to the prior art search itself. There are other differences with respect to the patentability search, is that additional factors are a consideration. So, one may be looking at the invention just from the point of view of not only just the non-patent or the patent literature, but additional sources. So, therefore, unlike the patentability search, the purview of the entire validity search is much beyond. So, that is where you can see the differences between the patentability search and the. So, what goes into the report of a patent validity or invalidity report, we need to take that into consideration. The first most important thing when you present to your client or you prepare a report on that is to define the purpose of the search. Understanding that is very clear. We have dealt with 2 examples in this lecture. Then discuss the difference between the prior art and the invention in complete detail. So, it is like actually writing a complete 1-page report or a research report on the exact difference between the interpretation of the claim terms in relation to the prior art in clear and lucid terms. And the prior art typically which is raised is other than what is raised by the examiner. The third important thing we need to look at it from when the report is prepared is the section where the discussion happens in relation to the claim mapping to the prior art mapping. So, the claim to prior art mapping starts with the explanation in relation to the taking up one claim at a time. So, you need to mention the claim number, particularly the independent claim. So, how this independent claim has a counterpart issue with respect to a prior art which is potentially can defeat the novelty of this particular claim, or an issue of a case of obviousness, and similarly some other aspects, other factors that we have discussed. It is possible that at times some relevant dependent claims are usually not taken up in a patent validity search, but depending on certain cases, certain areas, dependent claims also can become a part of the validity search, because in many jurisdictions multiple dependent claims are taken up as part of the patent claims, in which case this issue can come up where if the independent claim itself is struck off, the issue of the validity of the dependent claims does not arise. But however, in certain cases considering dependent claims also is necessary. It is not only important to look at the claim mapping, one should also look at the mapping of the description of the invention with respect to the prior art. So, here we take into consideration if any of the diagrams of the invention potentially can defeat the novelty, then those become an important consideration. There is a lot of case law where drawings alone constitute to defeating the novelty of an invention, in which case in some cases courts have ruled that drawing alone can actually be taken up for defeating the novelty of an invention. So, the diagrams and the description and how they are actually what is the relation with the prior art, that becomes again another important part. So, laying out the report of the patent validity in this particular fashion will provide a complete detail of the entire status of that particular patent in relation to the prior art on one hand and other factors. In some cases the file wrapper information is important. So, therefore, analysis of that also is important. One must remember that there are different proceedings at the patent office for review of patents post grant. Today, some of the jurisdictions offer more than one proceeding available at the patent offices. For instance, if you look at it from the point of view of the United States, USPTO has post the America Invents Act introduced many different proceedings. One is the inter partes review, the other is the post grant review. Today, the IPR proceeding has become a typical place where a lot of invalidity proceedings are taken up. So, the question of contesting the validity of a patent in a very short time of 12 months when made available at the patent office becomes a very attractive option. Less expensive, evidentiary considerations are different. So, therefore, With these different options coming up at the patent offices, it has become important to look at it from the point of view of the scope of bringing in the invalidity issues in relation to patents. Today, patent offices are also allowing for pre-issuance submissions at the patent office. So, a lot of prior art submissions are being made at the patent offices, and the patents which are of actually are not novel or not meeting the requirements under the given law are actually not going through the patent office, are not being allowed as grants. So, with these procedures introduced, it has now become a good option and has also become a very important area of practice. So, invalidity and patent validity searches are important from that standpoint. So, how do you really utilize the results of the patent validity or invalidity search? Planning for, in a case of patent infringement, planning the litigation, it helps in that. So, it provides you the option of looking at how the litigation, in what strength can the litigation move forward. So, from the plaintiff's point of view, asserting validity is very important. From the defendant's point of view, striking off the patent on the important grounds, on the main grounds of novelty, non-obviousness and eligible subject matter becomes fundamental. So, therefore, the entire search is centered around looking at raising the relevance of prior art to invalidate the patent on those 3 counts. It is possible that other factors also add to these grounds. You can bring in multiple grounds. Today, you find multiple defendants in patent litigation because of the various procedures that have been opened up at the patent offices. Many a times it does not require the defendant to be present during the proceeding at the patent office. So, it is possible that one defendant takes up, let us say, an IPR proceeding at the patent office, whereas the co-defendant is actually looking at the outcome of this to now launch a separate litigation in the court. So, it opens up a plethora of these possibilities, and so therefore, planning into the entire scenario of patent infringement is itself a very important aspect where you see the value of the validity searches. For a patent owner, it is important to prepare for patent enforcement. So, as a patentee, one needs to keep into mind that this of strengthening the value of a particular patent. So, for patent enforcement purposes, again the patent validity search is important. Prior to licensing out of inventions, both the patent owner conducts the validity search and the licensee, potential licensee conducts the invalidity search. So, prior to licensing, it is again an important option. Also, there is a link between patent validity to the freedom to operate. Many a time the issue of patent validity may not arise, but the case of the ability to enter into market will be affected at times because of the other patents that are there. So, again, in order to draft a good FT opinion, understanding the validity of a patent also becomes an important consideration. So, that is where we see the link between these two. Of course, there are several reasons for which we conduct the validity search, and today in the area of mergers and acquisitions, buying over of a portfolio of patents, it has become important to look at the aspect of patent validity, particularly in those industries where the domain is based on technology, value taken out of technology for making products and process. In the case of pharma and biopharma patents, understanding the context of validity search becomes important from looking at one, the reassignment information, and second, looking at the patent term extension. So, when you are looking at planning out to entry of generics into the market, we are potentially waiting for the period of validity to expire in relation to patents. Sometimes you may have a drug with a generic application which is ready, and you know that this has great value. One can actually look at even before the expiry of a patent to invalidate the patent and get into the market. So, there are procedures available. There is a procedure available under the in the US by way of patent linkage, where one can invoke the type of patent certification such that the generics enter into the market while during patent term, when an invalidation is potentially possible, when the patent owner reacts to the challenge which is posed. So, here you have a invalidation suit in the court and the entry of generics. So, this link is available in the case of the pharma and the biopharma patents. So, in summary, we have looked at the aspect of why the patent validity and invalidity search is important. This forms an important part of IP due diligence. There are various data sources which are considered in case of conducting this search. Coupling this in relation to either the patent office proceedings or the court proceedings is a strategy, and one must keep in mind that here the ability to analyze claim terms and claim scope, interpreting it in relation to a prior art, is the expertise one develops when one conducts a validity search. So, let us summarize on the aspects of what are the factors that are considered during the patent validity or the invalidity search. Understanding related patents, keeping in mind this is very important from the point of view of looking at the divisional patents or the patents of addition. What could be the effect on a patent family? Keep that in mind when you are actually conducting an invalidation search. In the case of pharmaceutical patents, calculation of the total period of patent is important before we embark on the search in relation to invalidation, because as yet the case of patent term extension applies. Litigation history is important to plan out actually how well one can actually invalidate a patent of a particular competitor or a company. For patent owners, it becomes important to look at the validity search from the point of view of limiting claims. And to prevent a future litigation, it may be good to limit claims at the patent office. Prosecution history is always something which haunts all patent owners, because that is one potential place where a lot of assertion of invalidity comes in from the point of view of defendant. So, take into consideration prosecution history aspects when you are looking at a invalidity search. Priority date itself of a patent can be challenged, and so therefore, ascertaining the priority date is an important consideration when you are looking at the search in relation to invalidity. Evidence of sale can be a good defense for validity of a patent. So, therefore, for patent owners, keeping into record the evidence of sale can potentially thwart the aspect of invalidation that can come up in relation to their specific patents. There are some of the references in relation to this particular lecture one can access from the book on patent search for tools and techniques and the patent search workbook developed in this particular course. Thank you.